G'day everyone, and welcome to the fourth and final video for week 7 of our legal ethics course. As you already know, this week we've been looking at the concept of conflict of interest. In the first video, we looked at conflicts between the interests of the lawyer and the interests of the client. Then in the second video, we looked at conflicts between the interests of two separate clients when the lawyer is trying to represent both of them concurrently. In the third video, we looked at conflicts of interest between the interests of a current client and the interests of a past client when we're being engaged to commence action against that past client. Now in the final video, we're going to look at one special case of conflict of interest. The conflict of interest that occurs if you're acting on behalf of family or friends. And then related to that, in this video, we're also going to look again at sexual or romantic relationships between solicitors and their clients. As always, we begin with the rules. There is no specific rule regarding acting for friends or family. That's one of the reasons this issue gets a video all of its own. However, Rule 4, which we've already run into, says that a solicitor must act in the best interests of their client and that a solicitor must avoid any compromise to their professional integrity or independence. Rule 12 says that a solicitor must not act if there is a conflict between their own interests and the interests of the client. And most importantly, Rule 3 says that the paramount duty of a solicitor is to the court and the administration of justice. What does all of this add up to? Well, it means that there is no specific rule against representing friends and family. But it's going to be super difficult to be confident that you're putting their interests ahead of your own. And even more difficult to be confident that you're putting the interests of justice first of all. Imagine this, your favourite cousin, someone you grew up alongside. She has 2 kids now and she's recently left her husband. It emerges that, unknown to everyone, she'd been the victim of domestic violence. Serious physical domestic violence, along with the psychological mistreatment and coercive control that often comes with it. When you find out about this, you're furious. And she comes to you and says, well, you're a lawyer. I need a lawyer. I want parenting orders that will protect my kids. And I want a protection order because I've got no idea what he'll do next. In that situation, any decent human being, any cousin worth the title, would want to step in and help. It's a normal part of family. If your car breaks down and your sister is a mechanic, you ask her to help. If your kid is struggling to read and your aunt is a teacher, you ask for advice. It seems like the most normal thing in the world for someone to say, I've got a legal problem and I've got a lawyer in the family. But can you see that if I'm furious because my cousin has been the victim of domestic violence, I'm not the right person to be representing her. No matter how hard I try, I'm going to struggle to put my duty to the court first. I'm going to struggle to see that situation with the dispassionate, clear, logical thinking that a lawyer owes to their client. I need to put my cousin in touch with a colleague, and then I need to concentrate on being a supportive cousin, not being a lawyer. Even in a situation less emotionally charged, say a house conveyance, I'm still going to feel loyalty to my family member, right? And if I have to give them advice they don't want to hear, it's still going to be in the back of my mind that I'm going to have to show up at the next family barbecue and see them there. Even with the best will in the world, it's just about impossible to do your duty to a family member as a family member, and to do your duty to family members as clients, and to do your duty to the court on top of that. Honestly, don't go there. A 2012 case called Legal Services Commission against Despina is a good example of how best intentions can go terribly wrong. Mr. Despina was in a relationship with a lady named Carol Cattell. She was pursuing domestic violence proceedings against a former partner and she asked for his help, which he gave in a general way. One of the things that he did was to purport to witness a statutory declaration by someone who claimed to have observed the domestic violence against Ms. Cattell. However, Mr. Despina was not present when the statutory declaration was actually signed. He witnessed it later. Totally not allowed. The only possible explanation for his behaviour is that he was trying to help Ms. Cattell. Things later went pear-shaped in a big way. Ms. Cattell then forged Mr. Despina's signature, and in order to prevent the court from being misled by that forged signature, he had to face the consequences of having falsely witnessed the document. This led to a finding of professional misconduct against him. It's easy to have sympathy. I mean, he was just trying to protect his partner from what he understood to be serious domestic violence. But he found himself in a spiderweb between his natural loyalty to his partner and his duty to the court. There is, of course, a definitional problem in all this. I mean, what's family? Clearly my sister is family, my spouse is family. A cousin that I haven't had any contact with for 20 years. Is he still family in any relevant sense? A second cousin who I've occasionally heard mentioned, but I don't recall ever actually meeting. Are they family? Friendship is no clearer. I mean, the mate that I met in the military 10 years ago and who I exchanged messages with once a year to wish one another a good Anzac Day. Are they a friend? Someone who I've never actually met, but who's a friend on Facebook and who occasionally likes my posts, are they a friend? Close mates of my ex-girlfriend who I'd stop and say hello to in a shopping centre, but who I never actually seek out nowadays. Are they a friend? There's no simple answer to these questions. It's ethics. You need to think on every occasion, is my relationship with this person the sort of relationship that's going to make it hard for me to give them independent advice? Is this the sort of relationship that might compromise my duty to the court? And if the answer is even maybe just a little bit possibly, then you're on dangerous ground. And it's time to explain that situation to the client and withdraw from acting. Now, there are a couple of specific rules that you need to know about. First and foremost, even though we're not doing advocacy for a few weeks yet, you need to understand right now that both the solicitor's conduct rules and the barrister's rules prohibit an advocate from cross-examining a friend. If you're cross-examining them, well, obviously that means they're not your client, but this is one of the clear rules where your ethical duties intersect with your relationship with family and friends. You cannot cross-examine family or friends. Finally, there's an exception. You are allowed to write a will for family and friends. You're even allowed to write a will where you're going to end up as the executor or as a beneficiary. But honestly, why would you? Why would you place yourself in that situation if ever the will was challenged by one of the other beneficiaries or by someone who thinks they should be a beneficiary? If you really want to write a will for family, and to be honest, I've done it, then if you're going to be a beneficiary, make sure that the testator, the person making the will, gets independent legal advice. Have another lawyer explain the will to the testators. Have another lawyer witness the signatures. An independent lawyer who gives the advice without you being present. The final topic I want to cover off on is sexual relations between a solicitor and a client, something that we touched on in week 1. This doesn't just mean actual sexual activity, it means everything else: flirting, dating, seeking their attention, any of that stuff. I mean, let's imagine you have a client, you think they're attractive, you're flicking through Tinder and suddenly there they are. What are the rules? Some professions, such as medicine and psychology, have made it all very clear. No hanky-panky with the clients. In the law, it's much less clear. There's no actual rule against forming a relationship with your client. However, this is ethics. The mere fact that there's no rule against something doesn't make it a sensible idea. Let's think this through. First and foremost, when a client comes to see you, there is almost always a power imbalance present in the situation. The client sees you as someone knowledgeable, someone helpful. The client is almost always, in some way, vulnerable to us as a solicitor. They have put their contact with their children in our hands, or the future of their business, or the disposition of their will, or their prospects of avoiding criminal punishment, or 100 other things. Under those circumstances, the law and ethics immediately presumes that the solicitor is in a position of unusually strong influence over the client. Similarly, it's well known that emotional arousal from things like stress can easily be misinterpreted as physical attraction. All of our clients are stressed in one way or another. Nobody comes to see a lawyer when everything's going great. What all of this means is that a client who may seem to be attracted to you may in fact be responding to the power imbalance between you, and they may be responding to the stress that they're enduring. Surely no reasonable person, no ethical person could ever want to commence a relationship under those sorts of circumstances. Now, I'm sure there are examples out there that would prove me wrong. I'm sure that there are examples of clients who married their lawyers and lived happily ever after. But the ground is ever so shaky. And then, of course, if you do commence a relationship with a current client, suddenly you're in the position of giving advice to a person with whom you're in a relationship. And if it's the start of the relationship, in the lavender haze, when you're perfect and they're perfect and everything is perfect, you're probably at your least capable when it comes to assisting them with a dispassionate, impartial mind. So, we come now to the end of week 7. For the last 3 weeks, we've been looking at the solicitor's duty to the client. We've looked at the duty to advise, the duty to follow instructions, the duty of confidentiality and its exceptions. This week, we've looked at the duty to avoid conflicts of interest, conflicts between the interests of solicitor and client, including those where conflicts arise due to family, friends or sex, conflicts between the interests of 2 current clients, conflicts between the interests of a current client and a past client when we're engaged against that past client. There's an old saying, sunlight is the best disinfectant. In other words, for conflict of interest, the surest answer is always to disclose, and then either avoid the conflict or get informed consent. The moment that you start keeping secrets, you have to think that perhaps you're no longer properly undertaking your duties to the profession. For the next 2 weeks, we're going to round out our discussion of duties to the client by talking about our duties when handling a client's money. We're going to look at the principles that underlie solicitors' trust accounts. I'll tell you straight up, it's pretty dry stuff. But the next 2 weeks are by far the material most likely to result in solicitors appearing in disciplinary proceedings. So it's dry, but it's important. See you next week.